Good morning, everybody. I'm your host, the Supreme Litigant. And before we begin, y'all already know the routine. If you haven't already, please go ahead and hit that like button, that subscription button, and turn that notification bell on. And I'll give y'all a second to do that before we begin. All right. So before we begin, I got to go and do something. So I'll be right back, y'all. All right, y'all. Sorry about that. So this is where we left off yesterday. We're going to pick it up right here. So let me move the screen down and then we'll get started. We have recently noted that the privilege against self-incrimination, the essential mainstay of our adversary system, is founded on a complex of values. All these policies point to one overriding thought: the constitutional foundation underlying the privilege in the respect of government, state or federal, must accord the dignity and integrity of its citizens to maintain a fair state individual balance. Give me one second. To require the government to shoulder the entire load, to respect the inviolability, I think that's what it is, of the human personality. Our accusatory system of criminal justice demands that the government seeking to punish an individual produce the evidence against him by its own independent labors rather than by cruel, simple expedient of compelling it from its own mouth. In sum, the privilege is fulfilled only when the person is guaranteed the right to remain silent unless he chooses to speak in the unfettered exercise of his own free will. The question in these cases is whether the privilege is fully applicable during a period of custodial interrogation. Let's see here. We are satisfied that all the principles embodied in the privilege apply to informal compulsion exerted by law enforcement officers during in-custody questioning. An individual swept from familiar surroundings into police custody, surrounded by antagonistic forces, and subjected to the techniques of persuasion prescribed above, cannot be otherwise than under compulsion to speak. As a practical matter, the compulsion to speak in the isolated setting of the police station may well be greater than in courts or other official investigations, where there are often impartial observers to guard against intimidation or trickery. This question, in fact, could have been taken as settled in federal courts almost 70 years ago in Braun versus the United States. In criminal trials, in the courts of the United States, wherever a question arises whether a confession is incompetent because non-voluntary, the issue is controlled by the portion of the Fifth Amendment, commanding that no person shall be compelled in any criminal case to be a witness against himself. In Braun, the court, notice how they distinguish this in criminal trials in courts of the United States. So I'm assuming that this was prior to the 14th Amendment. I'm guessing. I don't know. But anyway, in Braun, the court reviewed the British and American history and case law and set down the Fifth Amendment standard for compulsion, which we must implement today. There's a standard to it. Much of the confusion which has resulted from the effort to deduce from the adjudged cases what would be a sufficient, sorry about that, y'all, quantum of proof to show that a confession was or was not voluntary has been a form of misconception of the subject to which the proof must address itself. The rule is not that in order to render a statement admissible, the proof must be adequate to establish that the particular communications contained in a statement were voluntarily made, but it must be sufficient to establish that the making of the statement was voluntary. That is to say, that from the causes which the law treats as legally sufficient to engender in the mind of the accused hope or fear in respect to the crime charged, the accused was not involuntarily impelled to make a statement when but for when but for the improper influences, he would have remained silent. The court has adhered to this reasoning. In 1924, Justice Brandeis wrote for the unanimous court in reversing a conviction resting on compelled confession. In federal courts, notice they keep saying it in federal courts. But this, I mean, the 14th Amendment had to be allegedly ratified after that. So I don't know. It must not have been established in state courts yet or something like that. But anyway, in federal courts, the requisite of voluntariness is not satisfied by establishing merely that the confession was not induced by a promise or a threat. A confession is voluntary in law if and only if it was in fact voluntary. A confession may have been given voluntarily, although it was made to police officers while in custody and in answer to an examination conducted by them. But a confession obtained by compulsion must be excluded, whatever may have been the character of compulsion, and whether the compulsion was applied in a judicial proceeding or otherwise. In addition to the expansive historical development of the privilege and the sound policies which have nurtured, let me scroll down. Give me a second, y'all. Which have nurtured its evolution, judicial precedents thus clearly establishes an application to incommunicado interrogations. In fact, the government concedes this point as well established in Westover versus United States. We have no doubt that it is possible for a suspect's Fifth Amendment right to be violated during in-custody questioning by a law enforcement officer. Let's see. Because the adoption by Congress of Rule 5A of the Federal Rules of Criminal Procedure and this court's effectuation of that rule in McNabb, blah, blah, blah. I'm going to stop right there. Notice that they say because of the adoption by Congress of Rule 5. So Congress adopted that rule for their courts. That's what it seems like. For their legislative courts, their inferior courts. Notice that all legislation is territorial. All legislation is territorial. I'm gonna stop because I don't want to confuse y'all. But anyway, we have had little occasion in the past quarter century to reach the constitutional issues in dealing with federal interrogations. These supervisory rules requiring production of an arrested person before a commissioner without unnecessary delay and excluding evidence obtained in default of that statutory obligation were nonetheless responsive to the same considerations of the Fifth Amendment policy that unavoidably face us now as to the states. We recognize both the dangers of interrogation and the appropriateness of prophylaxis stemming from the very fact of interrogation itself. I've never heard of this word before until today. Never heard of it. This is why you need to read cases so you can expand your vocabulary and look up words. In our decision in Malloy versus Hogan, our decision in Malloy versus Hogan necessitates an examination of the scope of the privilege in state cases as well. In Malloy, we squarely held, I'm going to stop right there, and I'm going to read y'all this footnote from above 32. Our decision today does not indicate in any manner, of course, that these rules can be disregarded. When federal officials arrest an individual, they must, as always, comply with the dictates of congressional legislation and cases thereunder. I wonder why they keep bringing up Congress. Why? Because these are all administrative agencies enforcing statutes, civil law, admiralty courts or civil law. Civil law courts. Anyway, pay attention, y'all. Where did I go? In Malloy, we squarely held the privilege applicable to the states and held that the substantive standards underlying the privilege applied with full force to state court proceedings. There, as in Murphy versus Waterfront Commissioner, I'm guessing that's what that is, 1964, blah, blah, blah. We applied the existing Fifth Amendment standards to the case before us. Aside from the holding itself, the reasoning in Malloy made clear what had already become apparent, that the substantive and procedural safeguards surrounding admissibility of confessions in state cases had become exceedingly exacting, reflecting all the policies embedded in the privilege. The voluntariness doctrine in the state cases. I'm sorry, y'all. As Malloy indicates, encompasses all interrogation practices which are likely to exert such pressure upon an individual as to disable him from. I'm gonna read that footnote in a minute. From making a free and rational choice. All right, let's go back up. Sorry about that. The decisions of this court have guaranteed the same procedural protection for the defendant, whether his confession was used in a federal or state court. It is now axiomatic that the defendant's constitutional rights have been violated if the conviction is based in whole or in part on an involuntary confession, regardless of its truth or falsity. This is so even if there is ample evidence aside from the confession to support the conviction. Both state and federal courts now adhere to trial procedures which seek to assure a reliable and clear-cut determination of the voluntariness of the confession offered at trial. Appellate review is exacting. Let's see. Whether his conviction was in a federal or state court, the defendant may secure a post-conviction hearing based on the alleged involuntary character of his confession, provided he meets the procedural requirements. That's his remedy. Where there's a right, there's a remedy. Let's go down here. The implications of this proposition were elaborated in our decision in Escobedo versus Illinois, decided 1 week after Malloy applied the privilege to the states. Our holding there stressed the fact that the police had not advised the defendant of his constitutional privilege to remain silent at the outset of the interrogation, and we drew attention to that fact at several points in the decision. This was no isolated factor. Boy, I'm so dyslexic, y'all. I'm sorry. This was no isolated factor, but an essential ingredient in our decision. The entire thrust of police interrogation there, as in all the cases today, was to put the defendant in such an emotional state as to impair his capacity for rational judgment. The abdication of the constitutional privilege, the choice on his part to speak to the police, was not made knowingly or competently because of the failure to appraise him of his rights. The compelling atmosphere of the in-custody interrogation and not the independent decision on his part caused the defendant to speak. A different phase of the Escobedo decision was significant in its attention to the absence of counsel during the questioning. There, as in the case today, we sought a protective device to dispel the compelling atmosphere of the interrogation. In Escobedo, however, the police did not relieve the defendant from the anxieties which they had created in the interrogation rooms. Rather, they denied his request for the assistance of counsel. Let me see this heightened. I'm gonna read that too. Let me see where we at. How far are we at? Oh, well, we're at about 14 minutes. I'm gonna go a little longer. I'm gonna read y'all this footnote. The police also prevented the attorney from consulting with his client. Independent of any other constitutional prescription, this action constitutes a violation of the Sixth Amendment right to the assistance of counsel and excludes any statement obtained in its Let me go down. In its wake. All right, now let me go back up. It's kind of confusing that I'm doing this. This heightened his dilemma and made his later statement the product of his compulsion. The denial of the defendant's request for his attorney thus undermined his ability to exercise the privilege, to remain silent if he chose, or to speak without any intimidation, blatant or subtle. I'm sorry. The presence of counsel in all the cases before us today would be the adequate protective device necessary to make the process of police interrogation conform to the dictates of the privilege. I agree with that. His presence would ensure the statements made in the government established atmosphere are not the product of compulsion. It was in this manner that Escobedo explicated another facet of the pretrial privilege. Noted in many of the court's prior decisions, the protection of rights at trial. That counsel is present when statements are taken from an individual during interrogation obviously enhances the integrity of the fact-finding processes in courts. I agree with that. The presence of an attorney and the warnings delivered to the individual enable the defendant, under otherwise compelling circumstances, to tell his story without fear, effectively, and in a way that eliminates the evils in the interrogation process. Without the protections flowing from adequate warnings and the rights of counsel, all the careful safeguards erected around the giving of testimony, whether by an accused or any other witness, would become empty formalities in a procedure where the most compelling possible evidence of guilt, a confession, would have already been obtained at the unsupervised pleasure of the police. Give me a second, y'all. I'm going to stop right there. Let me see what else we got. All right, we'll go a little longer, a bit longer. Today, then, there can be no doubt that the Fifth Amendment privilege is available outside of criminal court proceedings and serves to protect persons. Notice they're talking about persons. Fictions, legal fictions, juristic persons, legal persons, juridical persons. Anyway, serves to protect persons in all settings in which their freedom of action is curtailed in any significant way from being compelled to incriminate themselves. We have concluded that without proper safeguards, the process of in-custody interrogation of persons suspected or accused of crime contains inherently compelling pressures which work to undermine the individual's will to resist and to compel him to speak where he would not otherwise do so freely. In order to combat these pressures and to permit a full opportunity to exercise the privilege against self-incrimination, the accused must be adequately and effectively appraised of his rights, and the exercise of those rights must be fully honored. It is impossible for us to foresee the potential alternatives for protecting the privilege which might be devised by Congress or the states in the exercise of their creative rulemaking capacities. Therefore, we cannot say that the Constitution necessarily requires adherence to any particular solution for the inherent compulsions of the interrogation process as it is presently conducted. Our decision in no way creates a constitutional straitjacket which will handicap sound efforts at reform, nor is it intended to have this effect. We encourage Congress and the states to continue their laudable search for increasingly effective ways to protect the rights of the individual while promoting efficient enforcement of our criminal laws. However, unless we are shown other procedures which are at least as effective in appraising accused persons of their right of silence and assuring a continuous opportunity to exercise it, the following safeguards must be observed. At the outset, that means at the beginning, If a person in custody is to be subjected to interrogation, he must first be informed in clear and unequivocal terms. Notice they didn't say illegal in legalese and all. They want is clear, clear as a glass of water. He must first be informed in clear and unequivocal terms that he has a right to remain silent. For those unaware of the privilege, the warning is indeed simply to make them aware of it. The threshold requirement for an intelligent decision as to its exercise. Let's go down. Let's see. More important, such a warning is an absolute prerequisite in overcoming the inherent pressures of the interrogation atmosphere. It is not just the subnormal or woefully ignorant who succumb to an interrogator's uh, imprecations. Imprecations, whether implied or expressly stated, that the interrogation will continue until a confession is obtained, or that silence in the face of accusation is itself damning and will bode ill when presented to a jury. Will bode ill when presented to a jury. They're using a lot of old words in here. Further, the warning will show the individual that the interrogators are prepared to recognize his privilege should he choose to exercise it. The Fifth Amendment privilege is so fundamental to our system of constitutional rule, and the expedient of giving an adequate warning as to the availability of the privilege so simple, we will not pause to inquire in individual cases whether the defendant was aware of his rights without a warning before given. I'm going to read this footnote. Assessments of the knowledge the defendant. I'm going to stop. Let me read this footnote. Let me see how much time we got right quick. All right. It is probable that even today, when there is much less ignorance about these matters than formerly, I would disagree with that. But anyway, there is still, well, they kind of got a point. Anyway, there is still a general belief that you must answer all questions put to you by a policeman, or at least that it will be the worse for you if you don't. In accord with our decision today, it is impermissible to penalize an individual for exercising his Fifth Amendment privilege when he is under police custodial interrogation. The prosecution may not, therefore, use at trial the fact that he stood mute or claim his privilege in face of accusation. In the face of accusation, okay. Assessments of the knowledge of the defendant. Assessments of the knowledge the defendant possessed based on, information as to his age. I gotta go in. Let me pause it right there, y'all. I'll be right back. All right, about 2 or 3 more pages, y'all, and that'll be it. Assessments of the knowledge of the defendant possessed based on information as to his age, education, intelligence, or prior contact with authorities can never be more than speculation. A warning is a clear-cut fact. More important, whatever the background of the person interrogated, a warning at the time of the interrogation is indispensable to overcome its pressures and to ensure that the individual knows he is free to exercise the privilege at that point in time. The warning of the right to remain silent must be accompanied by the explanation that anything said can and will be used against the individual in court. This warning is needed in order to make him aware not only of the privilege, but also of the consequences of foregoing it. It is only through an awareness of these consequences that there can be an assurance of real understanding and intelligent exercise of the privilege. Moreover, this warning may serve to make the individual more acutely aware that he is faced with a phase of the adverse. Moreover, the warning may serve to make the individual more acutely aware that he is faced with a phase of the adversary system, that he is not in the presence of persons acting solely in his interests. The circumstances surrounding in custody interrogation can operate very quickly to overbear the will of one merely made aware of his privilege by his interrogators. Therefore, the right to have counsel present at the interrogation is indispensable to the protection of the Fifth Amendment privilege under the system we have uh, delineated today. We delineate today, I'm sorry. Our aim is to assure that the individual's right to choose between silence and speech remains unfettered throughout the interrogation process. A once stated warning delivered by those who will conduct the interrogation cannot itself suffice to that end among those who most require knowledge of their rights. Okay, let's see what's that. A mere warning given by the interrogators is not alone sufficient to accomplish that end. Prosecutors themselves claim that the admonishment of the right to remain with without silent without more will benefit only the recidivist and the professional. Where is it at? Even preliminary advice given to the accused by his own attorney can be swiftly overcome by the secret interrogation process. I agree with that too. Thus, the need for counsel to protect the Fifth Amendment privilege comprehends not merely a right to consult with counsel prior to questioning, but also to have counsel present during any questioning if the defendant so desires. The presence of counsel at the interrogation may serve several significant subsidiary functions as well. If the accused decides to talk to his interrogators, the assistance of counsel can mitigate the dangers of untrustworthiness. With a lawyer present, the likelihood that the police will practice coercion is reduced. I agree with that. And if coercion is nevertheless exercised, the lawyer can testify to it in court. That's right, because he has first-hand personal knowledge and he's competent to testify. He's a witness. The presence of a lawyer can also help to help guarantee that the accused gives a fully accurate statement to the police and that the statement is rightly reported by the prosecution at trial. Yeah, because they'll lie. Boy, they'll lie. So look, man, they made this case. I don't know how old it is, but it's probably over. It's probably almost. Is it 100 years old? It was in 1990. No, it's not 100 years old yet. But this is a very old case, probably about 50, 60, maybe somewhere around that old. But they were talking about this then at that particular time because they already knew. They already knew this stuff, man. Where we at? How much time we got? We at 28. I'm gonna end the video here because I don't want to go over 15 to 30 minutes. So I'm gonna end the video here, and we'll do part 4. If not tomorrow, then sometime next week. Hopefully this helped y'all out. Please go and read this case for yourself. Please. That'll be the end of this video. The Supreme Litigant is out. Peace.